Good morning or good afternoon, everybody. This is Hannon Ford at the Ford Law Offices. And this year, of course, is a little bit different. We are doing our annual client meeting over the internet. um, in the future, this might seem a little strange, but you all know what's going on, so not strange now. This year's annual client meeting is going to be available online for about a month. We're going to take it down. So even if you don't watch it tomorrow, which is going to be Saturday, November 18th? No, November 21st, 2020. It'll be available for you a little bit after that, and you can share it with your kids or whatever if you want as well. But this is for the clients of the Ford Law Office in Windom, Minnesota. I have to say, since this is going online, that this is not legal advice. It is general legal advice and is not specific to your situation. Lawyer's disclaimer. You know how it goes. All right, so let's begin with the 2020 annual client meeting. First, typically at the beginning of every annual client meeting, I will introduce my family. They're not here with me right now. We sent them away for noise purposes. But let me give you a little update. Holly's doing great. She's raising our children really well with a little bit of help from me from time to time, but not too much. Um, our oldest Eliza is getting married next week. Very exciting for us. I will be gone most of next week traveling out to Utah, where she will be married in one of our church's temples to a young man from Payson. No, I'm sorry, Spanish Fork, Utah. The temple is in Payson. What else do you need to know? She's doing really well. I wish I could invite you all to the reception, but with everything as it is, that's not going to happen. um, let's see. Zadok is our next child, my oldest son. He just recently received a mission call from our church. He has been asked to serve as a missionary of Jesus Christ in Tempe, Arizona. Sorry, I'm making sure I get everything right before I say it. I'm not doing so well at it. But so he'll be in Tempe, Arizona for 2 years, preaching about Jesus to those who would like to hear. It should be interesting, especially during these COVID times. What else? Faith is next. Oh, I should also mention Faith and Zadok. Both are working at Hy-Vee in Windom. If you go to Hy-Vee in Windom, you probably will see them there from time to time. So that's exciting. Zadok is also in college right now. He's doing it online and doing really well. Eliza is finishing her last year of college right now as well. Okay, so I'm jumping all over the place. Faith is in high school. She's a junior. She's in the drama club, which just got canceled because of the COVID. Getting a lot of that. You guys know what it's like. Those of you who are still in Minnesota, most of you are, I know. Now, what else? She's working at Hy-Vee. She's doing great in school, and she's a great all-around girl. My last three, I'm just going to lump them together. They're eighth grade down to first grade, maybe second. Holly will tell me later. I'm so bad. But they're all doing really well in school. They were just recently sent home from our Windom area schools for a time, again, because of COVID. All right, so that's an update from my family. Um, let's update you on the office. So the Ford Law offices, just like always, we just have one office. It's been a great business plan, and I travel all over Southwest Minnesota to meet with people at their advisor's office, at their home. And at these times, if you need to meet with me and you're not comfortable coming to our office, keep in mind the law office that I have is exempt from COVID restrictions, even during the biggest of shutdowns, because of the estate planning that we do, which is an exempt practice. You can imagine why people might need it. What else? So you can come to the office, but if you're not comfortable coming to the office, that's fine. We will meet with you over video chat. We have secure video chat available. We have phone conferences available. And I will come to your home if you'd like, or your advisor's office if you'd like, or I'll meet with you across the window. We've done a few of those too, as is required by most nursing homes. That's the Ford Law Office. Here's our team currently. Myself, I'm the only attorney still at the Ford Law Office, and I intend that to remain the case until I'm getting really close to retirement, which I'm not. I've got at least, what did we calculate the other day? At least 18 years left before I can retire, if things go well. We also have Jill Knapp, our office manager, does almost everything that I need. Wonderful, wonderful person to work for me. And Kristen Theiner, also wonderful person to work for me. She is the client services coordinator, the main person that you will get on the phone when you call the office. That is our team right now. And I just have to say thank you to Jill and Kristen for everything they've prepared. They put almost everything here together for our meetings. And even though this meeting is a little different than most, they will be emailing you. They will be contacting you and helping you find it on the internet. We will be posting this on YouTube if all goes well. And it will be available again for about a month. One of the big important things for me in my office is I want to be the very best estate planning and elder law attorney that I can. So it's very important to me that I go to continuing education events. And I always am looking for something new, something better that I can bring back to these meetings, to my new clients, to my previous clients, and also learning new skills and finding out things that I can do better. Here are some of the list of things that we did in this past year. My favorite is the Heckerling Institute, not just because it's in Florida in January, which I enjoy, but because it is one of the best places to go and learn from the very best in the nation. I call them the guys smarter than me, and they teach me how to do things that I didn't know, teach me things, and keep me up to date on all the changes in the laws and all the things. I also went to a wonderful online class. It was an all-day class on charitable trusts and all the goodies that you can do with them. We will be mentioning a couple of things today about that. What else? Sioux Falls estate tax update, a wonderful update every year on all the changes and cases in estate planning. And then, of course, every year I need to go to the Minneapolis Estate and Charitable Gift Planning Institute. This is one that gets broadcast through the whole nation, but they actually do it in Minneapolis. So it's wonderful for us Minnesota attorneys to have it on our hometown. And this one is the one that updates you on all the cases, all the laws, all the changes. And so I really love that. It's just kind of a list for you to follow and update yourself on. So that's some of the education and training. Except for the online training, I think this 2021 is going to be interesting. Probably not going to have a whole lot of opportunities, but we'll see what I can get. We'll see what I can get. That's my problem. But I just want you guys to know that I want to stay up to date. I want to do everything the best I can. Some activities and awards. Again, not a whole lot of activities this year. Our workshop stopped about the end of February. So not a whole lot to brag about, but here's a few things that we wanted to let you know. I am currently the only certified elder law attorney in Minnesota, certified by the National Elder Law Foundation, which is the only agency that certifies attorneys in elder law. It's not just some place, it's the place. There's also another attorney now in South Dakota, so that I'm one of two in South Dakota certified as an elder law attorney, but the only one left in Minnesota. One of them moved to North Dakota. The other one, the other two, I'm sorry, the other two dropped their certification for one reason or another. I don't know why. I was nominated as a top attorney on avvo.com, avo.com. That's a website, a great place to find specialists if you need a family law attorney or a litigator or something like that. That's a good place to go to find specialists. Not a lot of people know about that place, but I go on there from time to time and answer questions. And of course, we did all the presentations that we were invited to do, like we always do. If you have family members or you move to another state, or heck, if I get hit by a school bus, right? You might need to find another good estate planning attorneys. Now, there's good attorneys in all 50 states, and these are some websites that you can search for one near you, or maybe a family member needs help finding one, and you could recommend these 4 websites. I put them in the order that I would use them for searching for good estate planning attorneys. The first one is I always recommend somebody like myself, a certified elder law attorney. You can find that at NELF.org, National Elder Law Foundation.org. Another good place is estateplanning.com. That is a place where you can search for estate planning attorneys like me. NALA, National Academy of Elder Law Attorneys.com, is a great place for other elder law attorneys. They are not all certified, but they are all practicing in elder law. And the National Network of Estate Planning Attorneys, the last one, that's where I started learning how to be a really good estate planning attorney. It's a great group of attorneys, and they would do a good job for your family and friends. Every year, we like to announce what our fees will be for the annual client fee for the year 2021. We're making no changes, the same price. It's something I am highly recommending people do, not just to make money for me, but because 2021 is going to be the year of possible changes. I don't think things have been ever so much up in the air as they are right now, not just politically, but legal changes and national environment changes that would likely affect many of your plans. And so this would be a year I would not recommend not being in the life plan. 325 is probably a little less than an hour and a half of my time. And if you were paying hourly, you would definitely pay more than that. Plus, you get the annual client meeting like this, and hopefully in person again soon someday, and things like that. Oh, and also, well, you guys don't get one, but I got my annual client meeting donut. I hope you got yours, right? I don't have time to eat that right now. Just thought I'd have some fun with you. I had to get some donuts. Okay, wouldn't be the annual client meeting without them. All right, so what are we here for? We are here for updates. There are three main things I want to talk about this year. One is just a quick update on the federal taxes and how it's changing. Then we want to talk about the Secure Act that was passed December of 2019. Not many people heard about it, but it was passed, and that was after our annual client meeting last year. So many of you, I hope all of you, received a newsletter from me talking about the Secure Act so you can prepare for anything you need to do. But we're going to talk about it as in person as we can today, so that you can get that information. Also, we will attach on the email with the website, not the website, with this video available. We will attach it to that as well so you can read it, or, if you never saw it or lost it or it just went into the round file bin. We also want to talk about all the things going on, possible future things. I don't like to focus too much on them, but I think this is a year that would be a good year to talk about, okay, these are things that could happen. There may be some of you that need to prepare for those things. It won't be for everybody, individual basis kind of thing. All right, let's start with the tax update and work our way through these three topics. The tax update. The federal exemption has gone up. It goes up with the interest rates with at a certain amount. So last year was 11.4 million. This year, 11.58 million per person. And it's going to continue to go up with that interest rate. I don't know exactly what it's going to be next year, but nobody does until they publish that. Right now, 11.58 per person means a married couple has 23.16 million before they have to pay federal tax. And that's great. That's a really high rate. We love it. That means that very, very few of my clients are going to be taxed, right, by the federal government, which is good because they want to charge you 40% of everything over that. For a single individual, of course, it will be just 11.58 million available and nothing else. The state of Minnesota, this is our state exemption of 3 million. It changed to 3 million this year, and it's intended to stay 3 million. Now, personally, I think they'll change it eventually, but right now the books say 3 million, so that's all we know for sure. 3 million per person means you can double that to 6 million per person without any difficulty. Some farmers and some small businesses, according to special definitions, which we've talked about in the past, can qualify for additional exemptions as well for up to 5 million per person. Theoretically, it's very hard to qualify for that. So I tell most of my clients, count on the 3 million, but don't count on the extra 2 or the total of 5 million per person. Remember, with both of a trust and as a married couple, you can use that double coupon and get 3 million for each of you. Getting you to 6 million before your family pays the state tax. Now, the state rate is from about 9.96% to 16%, and it goes up the more you have. Most people are about 10%, just to give you an idea. We also want to quickly mention gift taxes because it's going to become important in our educational part of today's workshop. There is a gift tax by the federal government. There is no gift tax by the state of Minnesota, so you don't have to worry about the state. Just push that out of your mind to the side. The federal gift tax is a $15,000 annual exemption per person, right? Which means you, and if you're married, your spouse can both give $15,000 to anybody you want. Every child could get $30,000 from a married couple. Every child's spouse could get $30,000 from a married couple. Every grandchild and great grandchild and friends and neighbors and favorite people, right? So 15,000 per person. What the annual exemption really is a limit that says, hey, if you gift this much or less, we are not going to make you file a gift tax return. We don't care about that. It's a small gift according to the IRS, right? A very large gift for most people. But the IRS is what matters in this case, and so you don't have to file a return if you gift 15,000 or less per person. However, there's another gift exemption, which is the credit for estate tax. We call it a unified credit because you can use it at death, that 11.58 million federal exemption, or you can use it during your lifetime, the 11.58 million. So just an example, let's say you gave away $5 million during your lifetime. Wait. Remember, we have the annual exemption. Let's say you gave $5 million and 15,000 away in your lifetime. And do you have to file a gift tax return? The answer is yes, you do, because you gave more than 15,000, right? And what does that gift tax return do? It tells the IRS that you have given away 5 million more than they allow without a gift tax return. So they get to take that information and they subtract it from whatever your lifetime exemption is at the time you gifted. At the time you gifted is very important. So you would have 6.58 million left this year if you died this year that you could still transfer to your family with no estate tax because you used 5 of the 11.58 million, 6.58 left. Now, let's go back to the federal taxes. It's 11.58 this year. It will expire in the year 2025. It's one of those laws that they write with an expiration date for political reasons. I won't go into why they do it, but we kind of know why. Most of us. If you have questions about why, I'll tell you later. But anyway, so when that 11.58 expires and goes back to the 5 plus interest, which will be something like 5.49 or 5.48 when it starts, when that happens, if you've already given away 5, all that matters is how much the exemption was when you gave it away. So if you had 6 left and it goes down to 5, you still get the 5. They're not going to take the 5 you gave away and subtract it from the 5. We talked about that last year. They call that the clawback, right? They're not going to do that to us. The IRS had a revenue ruling on that, which means we can rely that that is not going to happen if we do some gifting before 2025, which we are going to talk about. This is all kind of a foundation that we're going to build on so that we can understand some of the recommendations that we're going to be talking about later. Okay, so federal tax 11.58, gift tax lifetime unified credit exemption, whatever you want to call it, also 11.58, and it's the same exemption, right? So you can use that as well. So most of my clients could give away everything, right? If they were married, they could give 23.16 million away. If you're not married, you're limited to 11.58 million. What if you give away more than that? Well, then you pay tax on it, right? You pay gift tax on that. But I haven't done that yet. Okay, that was the tax update. Now let's move on to the Secure Act. Now, there's going to be a lot of details in the newsletter that you will get a copy of. If you didn't get a copy of it, maybe you saw this later or something like that. If you are a client of the Ford Law Office, you can call us and we'll send it to you so you can read the newsletter again. Let me go over it briefly and talk about why this matters. This law was passed, again, December 2019. It only affects retirement accounts. These are your IRAs, your 401ks, your Simples, Kios, whatever you want to call them. There's a whole alphabet, 403Bs, whole alphabet soup of retirement plans. But if it's a retirement plan, this is the retirement that you're getting that says, okay, once you reach retirement age, which, by the way, if you skip all the way down, is the age of 72 now for people who did not get to 70 and a half before the end of 2019. That's kind of tricky. Anyways, I'll get into details if I get going on that. I better not. So Once you're over 72, you have to take out your minimum distributions from retirement accounts. That's one easy way to know if it's a retirement account, because the people holding it for you tell you, you have to take this much out. It's required. Now, this year is a skip year. That's also a detail that I shouldn't bring up, but I did anyway. So you don't have to take your minimum distributions out this year. But in the year 2021, theoretically, you will again, unless they pass a law, which, is always true for everything, unless they pass a law. So I'll stop saying that. What is affected by this new law? There's several things that are affected. There's only 3 things that are really worth mentioning, and they're on this list, right? Number 1, after death, whoever is your beneficiary does not get to take it out with over their life expectancy unless they are your spouse. Spousal rollover still exists, so they get to roll it over. They can take it out over their life expectancy. If they are your child or your friend or your neighbor, your favorite person, they have to take it out within 10 years after your death, which means they have 2 basic choices. Number 1, take a little bit out each year until it's all gone within 10 years, or you wait till the end of 10 years and take it all out at once. Deciding which one to do is going to be dependent on your income tax rate. If your income tax rate is very high, you might want to take it out a little bit over 10 years to try to keep your rate from going up to the next level, right? Or I shouldn't even say high. If it's close to the next level, that's about it. If your income tax rate is very low, you could probably wait till year 10, let it grow, let it accumulate, and then take it all out at once and pay the tax in that 10th year. That's an individual choice that your kids will have to make. You won't. Not your problem. So it's those kids that are going to have to learn these rules, and we're going to be there to help them. We sure hope, right? What else do you need to do? The other thing that you want to know is the age limit of required minimum distributions, RMDs on the slide. RMDs, required minimum distributions, start at age 72 for anybody who wasn't already taking out required minimum distributions before the end of 2019. So if you turned age 70 and a half, the old age, before the end of 2019, you were required to take out your required minimum distributions, and you're under the old law. You're grandfathered in. Nothing changes for you until you die, right? For anybody who didn't get to 70 and a half before the end of 2019, or get to the point where they have to take out the required minimum distributions, to be exact, that's a tongue twister, they don't have to take them out until 72. So you get to go to a little bit older before you have to start taking it out. This is a really smart move. People are living longer. They really are. Doesn't seem like it, but they are. So you wait a little bit longer before you start taking out your retirement plan, or have to take out your retirement plan. The other thing that they changed that is really kind of cool is you can continue contributing. Before, once you start taking it out, you can't put it in anymore. But now you can actually contribute to a retirement account all the way until you die, even after age 72. Who is this useful for? People with high income tax. If you're saying, oh, I've got too much income, I'd like to pay less tax, I'd like to get that down, continue contributing to your retirement plan and deduct that contribution from countable income. It's a good move. All right. So that is the Secure Act in a nutshell. Please refer to the newsletter for other questions. And of course, if you're in the life plan, you can always schedule a phone conference with me and I can answer any questions you have. What do we recommend because of the Secure Act change? So I always like to think, well, there's got to be something to do about the changes, right? So number 1, I want you all to double check the beneficiary of your retirement accounts. In the past, some of my clients who've been with me for a very long time, we always used the trust as the first beneficiary for all kinds of reasons, good ones too, tax reasons, protection reasons, bloodline protection reasons, divorce and lawsuit protection reasons that we did this. But now, because of this 10-year requirement, if you leave it to the trust, they would probably have to take it out over 10 years or do some more complicated things to get it back to where we wanted it. So what does that mean? Number 1, make your spouse the primary beneficiary. Check and see if that's correct for your beneficiary by calling your retirement account management company or advisor or whatever it is, whoever's in charge of that for you, and have them give you the beneficiaries. If it is not your spouse, let us help you change the beneficiary to your spouse. Ask them for a change of beneficiary form. We'll fill it out, give it to you to sign, and mail it in, right? Super easy, but It's just nice. It's going to save you some work after you die. Well, not you, somebody else. But it's a good thing to do that now. That's the best choice, in my opinion. Second, if anybody has less than 400,000 in retirement account, you don't need to do anything. I mean, your kids are going to have to make a decision about how to take it out, but you don't have to do anything. If it's under 400,000, I don't recommend changing anything. Um, so if I have a retirement account and there's $100,000 in my retirement account, I do nothing. I check the beneficiary and that's it. I'm done. For anybody who has over 400,000, consider a charitable remainder trust. So what is a charitable remainder trust? Let's look. It is an irrevocable trust. Irrevocable means you can't change it after you sign it, with some exceptions. There's always a way around. But it's a trust that you can't change after you sign it, for the most part. It names beneficiaries and pays them out over their lifetime. It could be your lifetime for yourself and then your kids. It could be your kids and grandchildren who are alive at the time you sign it. Things like that are options that you get to choose there. Most people will say, okay, I want it to pay me for the rest of my lifetime and then my kids for the rest of their lifetime. You can do that, right? What this does is when you pass away, if your retirement account goes into this trust, even though the charitable remainder trust says you have to take it out over 10 years, it's basically in a charity now. And charity doesn't have that rule. It's an exempt. It's an exempt place. There are 5 other exempt places, including spouse is one of them, that don't have to take it out over 10 years. And so it gets to take it out a little bit over their whole lifetime. By spreading the income tax over their lifetime, they will pay at a smaller rate of income tax and end up with more money for people who have over about $400,000 or more. And of course, this all depends on how much it's making off of interest during that time. So no guarantees on that, but over the average, it would be a good number to choose for a cutoff. At the end of the lifetimes, so whether it's 1 or 2 generations, theoretically could be more, but they all have to be alive when you create the trust. That's the requirement. At the end of those lifetimes, the money that's left in there goes to charity. So there's this balance. There's this balance between how much you leave your family, how much you leave to charity. If it's done right, if you had let's say you have $500,000, 500,000 of retirement account. If it's done right, your kids get 500,000 and the charity gets 500,000. And over your kids' lifetimes, it pays out 5 to 7% each year. And they could even get more than that. But that's typically what you're expecting from this type of trust. So they get the money, paying it at a lesser income tax rate. Charity at the end gets some too. It's a great way to spread out your charitable remainder trust, pay less income tax, and instead of paying a bunch of income tax to the IRS, you end up giving some to your favorite charity at the end as well. Another requirement I don't have on here, but it's interesting to mention, your kids come first typically in these charitable remainder trusts, and the charity comes second. But there is a requirement that the charity has to get at least 10% of what was put into the trust, or the IRS will make you pay more taxes. Penalty. Okay, so future planning. Nobody's got a crystal ball. I don't know what's going to happen. This is a little bit more up in the air, political, and what do I want to say? Socioeconomic, if that's not too fancy a word, a situation in our country, right? We have to deal with Minnesota law. We have to deal with federal law. And a lot of stuff is happening right now. So, but what's my job? My job is to give you my best advice and tell you, here's things that you should think about, things that I would do in your situation. And everybody is going to be different on this one, right? Nobody knows for sure. There's a lot of contests happening. There's a lot of things happening. But this is what I think is going to happen politically. I think the House of Representatives is going to be a majority Democrat. I think the Senate is going to be a majority Republican, right? And, even with that, that doesn't mean everybody has to vote along party lines either. So you don't know for sure what's going to happen. But my overall recommendation, what I think is going to happen with all of the law changes, I'm just doing an intro for that, with all the law changes coming, is I think there's going to be a stalemate. You're going to see in the news cycle both parties getting on the news and saying, it's their fault nothing's getting passed. It's their fault nothing's getting passed. We want to pass this, but they won't let us. And the other party will say exactly the same thing. We want to pass this, but they won't let us. It's all their fault. It's going to be a stalemate for the next 4 years is what I think will happen. Don't know for sure, but That would be what I would bet on. Why does this matter? It matters because there's a lot of things that are likely or unlikely to change depending on whether there's a stalemate or not. Now, the first thing we want to talk about are the things that we know are going to happen because they're on the books right now. Number one thing that we know is going to happen is that the 5 million, or the federal exemption, which is right now 11.58 million, is going to expire in the year 2025. So January 1st of 2025 expires. Goes back to 5 million plus interest, which is, I'm told it's going to be about 5.48 million, but we'll see. Depends on where they count the interest from. That's where we left off last time. Because of this, there might be a client out there, might be you, who has over 5 million and you're single, or you have over 10 million and you're married. If you're in that area, the 11 is great for you. The 5 is not great for you. So this would apply to those people. There are two things that will affect you and will be recommending. I said two things. There's a few things that we'll be recommending for you. For people who are worried about the exemption changing completely, there's no law that says the House and the Senate can't pass a law that says we want the exemption to be 1 million. We want the exemption to be 500,000. We want the exemption to be 0. Let's give me some more of that taxes because we want to spend it. That's what government's good at. They like to spend our tax money, right? So, what are some other things that are currently accurate? I got to get back on track here. The spousal limited access trust, which is a special irrevocable trust, or a domestic asset protection trust. You'll see the acronyms there on the slides. They are available to use. Those are current law that we can use to remove assets from the estate. So if you're over the amount that it's going to go to in 2025, we can use our 11 million now. We have 6.58 million extra right now that we could put it up to into a SLAT or adapt. Everybody's got acronyms. Those are mine. We can put it in there and it can remove it from our estate as well. For people who are maybe just slightly over, maybe not, millions over, but maybe just slightly over, an L.L.C, limited liability company, can allow for discounting of estate value. And we talked about that, I think, 2 years ago. But just so you know, a limited liability company can give you a discount on the assets in the L.L.C. Great for farmers with real estate or other people with real estate. Great for people with stocks. Great for people who own businesses. So that a business that looked like it was 6 million could shrink down to 4 or 5 with a good discount, which means you're under the amount you don't pay the estate tax. Not right for everybody, but those are two things that we have on the books right now that are accurate, that we can do no matter what the future holds. Things we worry about. All right, so these are some things that could happen in the future. I don't think many of these things will happen, but there are politicians who are recommending these things. They're saying, this is what we want to do. This is what we want to do. We're going to do this. We're going to do that. It looks currently like Joe Biden will be the president of the United States for the next 4 years. Of course, there are contests about that, and a lot of people are saying a lot of things. I'm not going to give an opinion on that, but I will tell you, it looks to me like Joe Biden will be the president. Even if some of those contests are accurate, you got to change a lot of states to change that result. So it doesn't look like it. We got to just accept that. Maybe. Again, contest, right? But if he is the president, most of these things are on his platform. So these are things that he is going to want to try to push the Democrat Party as well. And that's, different ways to raise taxes. That's what it's about. Okay, so what could they do? They could decrease the estate tax exemption. It's automatically going to 5. And it'll probably be enough for them to go back to 5. And then they get to say, we won, we did it. Just by getting to 2025 without doing anything. However, like I said before, they could decrease it even more. The first time we had the estate tax was during World War II. The government needed more tax money, so they decided to implement the very first estate tax. Right? It was a new tax back then, and everybody who passed away get to pay a percentage of their estate. The exemption was very small at the beginning, and it's been raised over time. so that we only tax the very rich is always their mantra. So they could decrease the estate tax exemption. Next one, they can increase the rates. Right now, the federal rate is 40%. The projected rate, not the projected, it's not projected at all. It is the not recommended. What is it? It's his sorry, I'm having a brain freeze. His promise, his goal, I'm not hitting the right word, but you got the idea, I hope, is to increase the estate tax rate to 70%, right? 70%. That'd be a lot. Depending on the estate tax exemption, it can really hurt for those people who are over that. Next one, they could increase the capital gains rate. His proposal, and this is President Biden when I'm saying his, is to increase the capital gains rate to double it. Right now, for most people, it's between 22 and 27%. It's theoretically possible to get 12 and 15. It's theoretically possible to pay 42%. By the way, this is Minnesota, where you add the 15% federal and the 7-point-something% state to get roughly the 22% or the 27%. It's different for everybody based on your income in that year. So the capital gains rates are linked to your income in that year. If they double them, very bad. That's more taxes for us. I don't like that one. I don't like any of them, but I don't like paying taxes either. If you do, then you'll be happy about these, right? Okay, next. The loss of the stepped-up basis rules. Currently, when you pass away, the land or the stock that you bought low gets a stepped-up basis to whatever the value is on the date of your death, right? So most of my clients are farmers. Imagine you bought some land at $200 an acre back when, 50 years ago. Now what is it worth? Let's say it's worth $8,200 an acre, right? That's a gain of $8,000. And when you die, if it's worth $8,200 when you die, your kids will get a stepped-up basis when they inherit it from you at $8,200, which means if they sell it the next day, they would pay zero gain, capital gains tax. If they get rid of that, then they would pay the tax just like you would pay the tax if you sold it. Stepped-up basis is a wonderful rule that lets families sell assets and not pay tax on the gain of that asset after somebody passes away, with it includable in their estate, which is what we have right now for everybody out there. So we would not like that to happen. This is a bill that's been proposed in the past, and it never made it to the floor. So not likely, but it's a concern because it's on the list, the to-do list. I'll call it the to-do list from now on. Yeah, that's a good one. All right. Second to last one, tax gains on death. What if they don't even wait for us to sell the property or the stock? What if they just say, okay, you died, it gained $8,000, same story that I told you before, your estate has to pay a capital gain on that. Add the capital gain of, let's say, 32%, because it's on death, and you'll have a lot of gain on death, to your estate tax of 40 or 70%. Guess how much the federal government's getting? That would be really nasty tax, but it is proposed. So we don't want that, but we got to worry about this a little bit, not too much, honestly. Don't worry about it too much because I believe in that stalemate. Okay, last one. Limitations on gifts. One proposal right now is that the annual gift exemption of $15,000 or the lifetime gift exemption of $11.58, we change it. We get rid of it. We say, hey, you can only make that gift 10 times, or you may only make that gift once every 10 years. Lots of different ways for them to tax us more on gifting. Eliminate the lifetime gift. Limit how many times you can do the annual gift. You can see a lot of different ways that they can tax us here. All of these are all about, do we want assets in our estate, or do we want to give them away now while we can? There's a balance between the estate tax and the gift tax. There's a balance between, do we give it away now and let our kids have it, or do we want to keep it so that we can use it and control it while we're still alive? That balance is very tricky. So let me give you some advice on what you can do. My first advice, and this is what I would do, just wait and see. Let's wait and see. Most of these things, if they start coming down the pipeline, I get a little bit of understanding that it's going to happen before it happens. We usually get a time limit. For example, the Secure Act. We had 11 days. That's a terrible example, honestly. No, 12 days, because 30 days of September, January, November. Yeah, 31 days in December. So we had 12 days in December to make changes before it happened. Not that we could have really done anything about that one. But most laws, they're going to pass them and they're going to say this starts on such and such a date. So we will get time. You can wait and see without losing all opportunities. But that's only most of the time. So number 2 recommendation, what if you're not comfortable waiting and seeing? What if you have a larger estate and you're worried about the 11 coming back down to 5 and you having to pay a whole lot of tax at 40 or maybe 70%? You can use gifting rules now. If you're comfortable with it, gift the $15,000 to each child. If you're married, you give 15 and your spouse gives 15. You can use your lifetime gift. Now, before using your lifetime gift, I highly recommend coming in, sitting down with me, talking about the pros and cons. Because when we do a lifetime gift of a large amount of stuff, we're talking about a whole bunch of rules. Nursing home rules, which we're not talking about today. Stepped up basis rules, which you don't get a stepped up basis when you gift. You only get it when you die with it. What else? Those are the 2 main ones, let's say, for now. But there are other things we need to talk about before you make a mistake and gift away something you really didn't intend to do. All right, what else could you do? You could create one of those irrevocable trusts we talked about. You could create a spousal limited access trust, a SLAT trust. You could create a domestic asset protection trust. We'll talk about those in detail in just a second. You could create an LLC to discount things. So, those are the 4 things that you could do right now. My favorite one is number 1. I'd wait and see. I think there's going to be a stalemate. I don't think there's going to be a lot of things that change, except for the one thing we do know, the 11 going back down to the 5 million of estate tax exemption. All right. What is a spousal lifetime access trust? I'm telling you to possibly think about doing this, but I'm not telling you much about it. So let me tell you just a little bit about it. This is an irrevocable trust, right? Irrevocable is a way of saying, I'm going to take this outside of my estate. So it removes the assets from your estate. We do it by using our lifetime credit, the 11.58 million credit. We use some of that now to get it outside of your estate. The spousal lifetime access trust says this is not includable in your estate anymore, and it can't be for your benefit, but it can be for your spouse's benefit. And I like to say, if you're sleeping together, you can probably get her to give you any money that you need to, or him to give you any money, vice versa, right? Both ways. Sometimes that's not true. So you wouldn't want to do this if you can't access your spouse's money, right? But it's a great way to give yourself access to money, keep control, but keep it outside of your estate. So this is a relatively new type of trust, but it's very useful for anybody who's nervous about this. It will not change your income tax. If it is written correctly, it'll be what the IRS calls a grantor trust, which means you'll pay the income tax like you always did on the interest, but it's still outside of your estate. You can write it another way too, but most people would not want to do that. So that's a spousal lifetime access trust. The idea is you're getting money out of your estate. You're giving your spouse access to that money, not yourself, just your spouse. And you use it before the estate tax credit expires and goes back to 5. Now, this next trust is available to both of you or whoever you name as beneficiaries. It is also irrevocable. Remember, that means nobody can change what they decided to do with the trust, with small limitations. A domestic asset protection trust is only allowed in certain states. Certain states have said, hey, you, the client, the beneficiary, you can create your own trust and say, I'm the beneficiary of this trust. And if you do this in a state like South Dakota, which I recommend since I'm licensed in South Dakota as well, then you have full access to it and it is outside of your estate. Another benefit, it's not on the list, but it protects it from almost every creditor you could have. It needs, however, a South Dakota trustee. Typically, you're going to hire a trust company. Now, there are other ways to do it. There's some fancy ways you could work this out, but I would recommend you have a South Dakota trustee if you want it to be excluded from your estate for estate tax purposes. That means there's going to be some money required to pay whoever is going to be your South Dakota trustee. And there's a lot of South Dakota trust companies to choose from. And of course, the purpose is to remove assets from your estate using your lifetime gift amount. of 11.58 before it expires to 5 or other changes happen. This is something we can do now, and if you decide that this is right for you, we would want to get together and talk about it. All right, we've gotten through the update part. I'd give you a break, but you can hit pause and give yourself a break. I'm going to take a drink and continue on. So our educational program this year, I was thinking about something that I thought would be really helpful, something we haven't talked about in a long time. And it's a question I get all the time. Who do I get this question from? I get it from your kids, my clients' kids, right? They call and they say, Mom is going to the nursing home, or Dad is in the hospital. We have his power of attorney here. What do we do? How do we use it? What's the deal? Or they have their healthcare directive. Now, these are two separate documents, and everybody gets them confused, and everybody doesn't know what to do when that time hits. So let's talk about them today. That's going to be our educational portion for this year's annual client meeting. So let's start with power of attorney. Power of attorney is a document that you sign that gives somebody else authority to do things for you. Now, if you followed my recommendation, you gave them the power to do everything that you can do. They step into your shoes and can sign your checks and pay your bills and contact people for information and do all these things. Now, at the very beginning of your power of attorney, now, if you want to look at it, you get out your estate planning book, flip to the tab that says power of attorney or powers of attorney, and you'll see your power of attorney there, right? The very first page, look for big, bold, all caps letters. And those letters should, for most of you, this is what will be there. It will say that the attorney, in fact, that's the name of the person in charge. It says they cannot exercise the authority you've given them until the things in Article 2 have occurred. Now, if you flip the page over and look at Article 2, it will say what has to occur before they can use it. For the majority of my clients, they have said this. They have said this power of attorney cannot be used until my panel has decided I am incapacitated. So we did a little trigger. We said, unless these people, and it's typically a doctor, a spouse, maybe kids, maybe more people, your panel is right there on page 2, and it says, until these people agree that I am incapacitated, nobody can use this power of attorney. So how does that translate to real life? In the real world, Dad's going to the nursing home and they're looking for the power of attorney because somebody asked them for it. Maybe it's the bank. Maybe it's the nursing home, even though they don't need the power of attorney unless it's for the contract. They usually should be asking for the healthcare directive. That gets really confused. We'll talk about that in a minute. Don't want to get too confusing yet. So they ask them for the power of attorney, and the kids say, here's the power of attorney. And the people will say, you're not authorized. And the kids throw their arms up in the air and say, what? How come I'm not authorized? Hannon did a terrible job. And then they call me. Why am I not authorized? And I will explain. It's because your parents, when they signed this, decided that they will not authorize you to do things for them until they are incapacitated. Let me send you the piece of paper that everybody needs to sign, right? So then I send them the piece of paper. They get the doctor to sign it if there's a doctor on there. They get the specialist to sign it if there's a specialist on there. They'll get the kids or the spouse to sign it. And once all those signatures are signed on there, then they are authorized to use it. See how that works? The trigger, the springing power of attorney, attorneys call it, it doesn't spring and make it available until everybody's signed. Now, there is one other way you can make it available for your kids if you want to make it immediate, and that's signing the page at the very back that says authorization for attorney in fact. If they signed that page, then it wasn't the panel that authorized the attorney, the power of attorney. It was the client. It was the parent. If they sign the back, then they're authorized automatically. Right? So 2 ways to authorize those types of powers of attorney. Number 1, the whole panel signs. Number 2, the client signs it, the person who wants them to act for them. Now, sometimes they can't sign it. Sometimes they are incapacitated and they don't have the legal authority to do that. And so then the panel would have to do that. So let's look at this for just a second, this slide on power of attorney. Who's in charge? That person is called the attorney in fact. Many people say the word power of attorney and they mean the person. That's actually the name for the document, but that's nitpicky stuff that doesn't really matter. If you know that that's the person in charge, that's all that matters. What are they allowed to do? They are allowed to do all the powers in that power of attorney. Some clients may have said, I want them to be able to do everything except for this one thing. That's rare, but it has happened, right? But most of my clients have full authority. When are they authorized? If there is a paragraph that is in all bold and caps on the first page, they are only authorized when they are incapacitated and have either signed the authorization themselves or the panel has signed the authorization. So that's how the power of attorney works. You will be able to look at your power of attorney now and see if you have a springing power of attorney. If you do not have a big paragraph all in caps on your first page, then you have already decided, you know what? I'm going to give power to my kids immediately. The moment you signed it, your kids could take that power of attorney and do everything for you, including steal all your money and run to Vegas, right? As I like to joke around. So they would never do that, we hope, right? But they're authorized to do everything immediately if you don't have the big bold paragraph. The other thing that you want to check is the very last page in that section. The very last page is the authorization for attorney in fact. If you've signed that page in front of a notary, they're also authorized, even if there is the bold paragraph at the beginning. So that's powers of attorney. Things you need to know about this. Remember, powers of attorney are for handling your business and financial and contract affairs. All of the work that needs to be done around you to handle your business and finances. That's the power of attorney. It is not for healthcare. There was a time we called it a healthcare power of attorney. We don't call it that anymore, not since 1989 in Minnesota, right? So it's been a while. But sometimes you'll have people say it wrong, and that's okay. We'll just try to correct what we need to. Now let's talk about the healthcare directive. The healthcare directive is not a financial power of attorney. If somebody at the bank asks you for the healthcare directive, they don't know what they're talking about. Vice versa, if somebody at the nursing home says, are you the power of attorney? They should be asking you, are you the healthcare agent? It's the healthcare agent who makes healthcare decisions. Not financial, healthcare. What are healthcare decisions? Do we operate? Do we resuscitate? Where do I live? Do we accept this type of care or that type of care? Do we use this pill or a different kind of pill? The doctor should consult with the healthcare agent, and the healthcare agent will help them make the best decision for the parent. What do they do? Well, we've been talking about that. I guess that's where we're at. The person in charge. Let's start with the who, though. The person in charge, looking at the slide, is called the healthcare agent or the agent, right? Some people will call you the healthcare power of attorney, and that's okay. It's a little old. Some people will call them the living will person, right? That's also old, but it's okay. We all know what people mean, right? They mean the person in charge of healthcare. But what you need to know is it's the healthcare directive, that document, which is under the healthcare tab in your book. They're the ones making healthcare decisions. I want to skip down to the bottom. When are they authorized? So this is different than the power of attorneys typically. My typical healthcare directive says, if you, the client, can't make decisions for yourself, then they're authorized. And there's nobody who has to sign anything. So, it works like this. You're in the hospital. The doctors know you're in a coma, but they need to know whether they can operate or not. If they can't talk to you, the healthcare agent is authorized to talk to them. If they're not there, then they can say, hey, I can't make the decisions. The next person on the list can make the decisions. This is a lot easier than the healthcare power of attorney. But we're not talking about, theft or stealing. We're just talking about whether they operate or not. Which one's more important? I don't know. But we've made it easy for the healthcare agent to take over when it's time to take over. And you'll notice on both of these documents, there's lots of backups. We wanted lots of backups. But I always recommend you have them make the decision one at a time. Right? One at a time works best so that we don't have to have a committee meeting. We don't have to worry about, in an emergency, calling all 6 kids or whatever the number might be, right? Now, when there is time, let's say you're on your last days, you're on your deathbed in some type of care or whatever it might be, it would be great if they talked to everybody first. But the buck does stop with the healthcare agent, right? They make all the healthcare decisions, and they are authorized. One last thing I want to talk about for the healthcare directive is the HIPAA authorization. It's typically right in the same area as the healthcare directive, and it really kind of belongs next to it at all times. So when you give a copy to your clinic, your hospital, your doctor, you give them a copy of the HIPAA authorization along with your healthcare directive. Now, there's a list of names on there too, but there's not a one at a time on this list. It's everybody on the list is authorized to do what? They can get your information. So they can ask the doctor, how's my mom? How's my dad? How did the operation go? What's the prognosis, if that's the right word? So they can find out information. They are not authorized, not all of them, to make decisions and tell the doctors what to do or pull the plug, right? That's only the healthcare agent. So there's a difference. HIPAA, get information. Healthcare directive, make decisions, enforce decisions, all those things. All right, so that is the healthcare directive. That was our educational portion for this year. Let's see, how far have we gone so far? We have gone about 55 minutes. We've just got a few things to wrap up, like we always do. So let's talk about funding your trusts. The number one problem with trust today, hopefully not for my clients, but in general, the number one problem is you have an asset that is not in your trust or not beneficiary to your trust. So if you think of an asset you don't have in your trust, maybe you bought a new car, maybe you started a new account. My staff will send you your red check list. We call it the red check review, but it's an asset list. And we check to make sure everything's in your trust. If you need help getting something in your trust, just call us. Work with Jill, work with Kristen, and they can help you get it in your trust. We'll contact the advisors. We will help you complete the forms correctly. We'll prepare them and get you ready to sign them. We might need some information from you because, we're not going to be able to just change the beneficiaries without knowing the account number and the place it's at, things like that. We will send you your report each year that you're in Life Plan, and you can update us each year at no additional cost. It's all included in the cost. Okay, that is the funding review. You think of something you need done? Give Jill a call. All right, what are our commitments? Our commitments this year. You're not going to get a big folder full of lots of papers to remind you of these things. So this is your paper right here. This video and the presentation that we emailed along with it. What is your commitment? Call us, right? Call us if there's a change. Call us with information. We want you to be up to date. Every time a client passes away, and at my age, it's happening a lot now. I remember when I started, there were several years I never had a client die, and I thought, ooh, I'm great. I'm really good at this. Never had a client die. But now, it's different. We want you to have everything in the right place when you pass away. If you do that, things are very simple and very easy for your kids or your spouse or whoever to take over. Call us with suggestions. If there's something that's not working for you, maybe you hate my puns, maybe you don't like me making jokes about politics or anything. Go ahead and make that suggestion. I need to hear that so that if I'm completely oblivious to me being rude or contradictory, or maybe you just have a suggestion. There's lots of suggestions I've gotten from clients over the years that I've incorporated and have improved people's documents. Update your asset report, right? Make sure that's up to date. It doesn't have to be to the penny or to the dollar. That's not a big deal. But if there's a significant new account, if there's a small new account, let us know. If there's a significant change in an account that's already in your trust, let us know. If the land values have dropped or increased, we need to know that so that when we look at the bottom line of your asset list, I can tell you, hey, you really should think about doing an LLC, or hey, you really should think about gifting some more to your kids and saving some taxes. That information is very important so that I can give you really good advice when we're talking. All right, what's our job? Our job is to make your requested changes and get them back to you so you can sign them, or have you come in and sign them. Our job is to keep up to date. 2021, it's going to be an exciting year for me because I'm going to be always looking at these changes that might happen and whether they're going to pass or not. Boy, is it going to be like watching the Super Bowl every time they put a bill on the floor and start voting on it for me. For you, ignore it. It's not your job. I'll let you know the score at the end. And if something serious changes, we'll notify you in time, as long as they give us, some time, which they usually do. All right. Anything else? As always, here's a to-do list for you, things that should be done by you. Your personal property lists. Every year we talk about those personal property lists at the back of your book, and highly recommend you making sure that your grandmother's yellow pie plate or your grandfather's clock goes to the person who you want it to go to, and it stops everybody else from getting upset when somebody comes in and grabs it. And even if it was the person it was supposed to go to, some people thought it was supposed to go to them, you know. Great for guns, jewelry, family heirlooms. Put them on that list and fill that out. Most people still aren't doing it, so we keep after you. Next on your to-do list, think about going to the funeral home and planning your funeral. It's a great gift to your kids to not have to plan things for you after you've passed away. They're mourning, and they're not going to do a great job. They want to do a great job, and so what they end up doing is spending more so that you'll be happy because they see you up on that cloud. You're watching them, and they're hoping that you are satisfied with the job they did. And then, of course, call us, email us. Questions are free. I'm much better over the phone than over email because I get a lot of emails. If you do send me a lengthy email, call us as well. Let us know that it's there so that I don't miss it with the hundreds of emails that I'll get every day these days. We have an email there that is mine. You can also email Jill or Kristen using jill@mnplans.com or Kristen@mnplans.com. We've got our webpage there, which gives you our contact information as well. We also have a Facebook page now, and of course this YouTube channel, where you'll be able to find some information. I think now that I've learned all these skills, I had to learn a lot to get this done. I'll probably be making some more educational videos, and maybe even part of this will become a clip that I leave up here. I intend to take the annual client meeting down after about a month. Don't expect this to always be there, but the educational portions I think would be useful for you and the rest of the world. I just don't want to give away free legal advice on YouTube to the whole world, just my annual client meeting people. All right, and that's YouTube. There's our phone number there as well if you need it, so you can contact us. Just keep in mind I will be gone next week for a wedding in Utah. Very exciting. My first. And what else do you need to know? That's our annual client meeting. We appreciate you. You should be getting your bill for 2021 near the end of December. And we'd appreciate you if you sent that fee in if you're decided to stay in the life plan program. Keep in mind, if you drop out of the life plan program, you pay hourly for questions and changes and any work that we do. So it's a pretty good deal for most people. And for some people, it's not the right thing, right? They'll do something else. We wish you well and a good health to everybody, and have a great Thanksgiving.